Thank you all for joining the Federalist Society for the Supreme Court Roundup with Thomas Dupree and Misha Tseytlin. My name is Tiffany Pages-Sanchez, and I'm a programming director with the Federalist Society. Mr. Dupree and Mr. Tseytlin today. Thomas Dupree is the partner in charge of the DC office of Gibson Dunn. He's also co-chair of the National Appellate and Constitutional Law Practice Group at Gibson Dunn. He's an experienced appellate and trial advocate, having argued over 90 appellate cases in federal courts, including all 13 circuit courts and the United States Supreme Court. Before joining Gibson Dunn, he served at the Department of Justice, where he was Deputy Assistant Attorney General and later became Principal Deputy Assistant Attorney General. In this capacity, he was second in command and oversaw over 900 attorneys. He's also a graduate of the University of Chicago Law School, where he served as editor of the Law Review and graduated with honors. After graduation, he clerked for Judge Jerry Smith on the Fifth Circuit. Misha Tseytlin leads Troutman Pepper's Supreme Court and Appellate Advocacy Group. He has most recently argued and prevailed in the Supreme Court on several important issues like redistricting as well as regulatory takings. Before joining Troutman Pepper, he served as Wisconsin Solicitor General, as well as Deputy Attorney General and General Counsel in West Virginia. He's a graduate of Georgetown University Law Center, where he graduated summa cum laude, and he has extensive clerkship experience, having clerked for Judge Kaczynski on the Ninth Circuit United States Supreme Court. So with that, please join me in welcoming Mr. Dupree and Mr. Tseytlin.
Thank you, Tiffany, for that awesome introduction.
Have you ever seen someone at one of these talks be able to do that whole thing without a single note
really impressive.
and like get everything? That was really
really good. Although I will add one item to Misha's resume, which is before launching on his impressive career of public service, he was a lawyer at Gibson Dunn, and in fact, Misha, I think, holds the record for the number of times any individual has actually been hired by Gibson Dunn. Because when I first hired him, kind of, coming off of his, summa, whatever, from law school, hired him, and then Misha began the first of what really was kind of, a clerkship journey through all levels of the federal courts, right? I mean, multiple appellates, Supreme Court, but it wasn't consecutive. It's like, he would clerk, he would come back, and I'd hire him again, and then he'd clerk again, and then I'd hire him again, and then I'd come back, and finally after the Supreme Court clerkship, I figured unless he's going to go to like some intergalactic court to clerk, that was it. So, anyways, but it's good to be here with you, Misha.
So Tom worked with me. I worked for him when I was much younger, and so I show up today, and he goes, "Misha, you kind of look put together now," which is kind of a both sides thing, right? On one hand, it's like, "Oh, thank you, I have like a suit," but then on the other, it's like, what kind of mess was I before when I was working for Tom back in Gibson Dunn?
Exactly. Well, we're really excited to be here today to talk about the Supreme Court. Obviously, the new term is underway, and certainly it's shaping up to be another blockbuster term. I mean, we said that about last term, and it was a big term last term, and this term seems to be equally momentous, at least potentially momentous, in terms of changes in the law. So Misha and I were going to talk today both about just the Supreme Court generally, kind of some of the larger trends that we're seeing and keeping an eye on, and also flag some of the more salient cases on the docket for this term. But before we kind of dive into the specific cases, just kind of at a 30,000-foot level, I mean, it's exciting in that we are now kind of, beginning the era, or a year or two into the era of really kind of a solid conservative majority on the court. For many years, including, years in which kind of, we would regularly be up before the court, you were dealing with kind of a 5-4 majority. And, the change from 5-4 to 6-3, hard to kind of, overstate the difference that makes. If you are litigating at least one of the kind of more, politically contested constitutional cases, as you all know, so many of those were decided by a 5-4 margin. And so when you've got that kind of extra vote in there, when you go to 6-3, it really changes the landscape. Obviously, it means that, you can afford to kind of, lose a conservative and still maintain a 5-4 majority. And so I think it's going to have, or it already has been having, a very significant impact, not just kind of in the outcome of cases, but also just in the cases that the court is willing to add to its docket. As you all know, the Supreme Court has discretionary jurisdiction. They take 1% of cases, 1% of cert petitions get granted. I mean, if you control for prisoner filings and the like, it goes up to 4% or something. But obviously, they're still denying the overwhelming majority of cases that are offered up to them for review. So they can be exceedingly selective, and they are exceedingly selective about what cases they're going to put on their merits docket. And so I think when the court went to that 6-3 majority, there was certainly a sense out there that kind of now was the time when the court felt that it was going to grant in cases, abortion, gun control, affirmative action, kind of a lot of these hot button issues now that they had kind of that working 6-justice majority. So in many respects, kind of the action that we've seen from the court is really kind of following a path that I think a lot of folks had anticipated, when the lineup changed. I guess one other thing, just to kind of set the stage, is the dynamic on the court is also interesting in that I think if you just go, based on what you kind of, read in the newspapers, you would think that the 6-justice conservative bloc just votes kind of as a whole, as a unified, kind of crazed right-wing bloc. And as we've seen, that's simply not true. I mean, there are a lot of cases where, 1 or 2 of the conservative justices vote for the liberals, or vote with the liberal bloc. You see cases in which, some are still pending decision, where at least based on their questions from the bench, the conservatives are not all aligned, that conservatives can and do split over these important issues, original meaning of the Constitution. Not all conservatives will agree. And so again, I think if you actually look at the way the court is deciding the cases and you kind of can get some insight again into the questions that they're asking at argument, I really think it does show a much greater diversity of thought and approach to the law within that 6-justice conservative majority than you might anticipate if you just believe what you read in the papers.
Great. So I'll give, first of all, thank you so much for having me here. It's good to be back with Tom for the second straight year. I see a couple of familiar faces from last year. So I'll talk about 2 aspects of the current court. One is that we do have a new member of the court, Justice Jackson. And when I was speaking about how she would be on the court doing some of these kind of panels when she was nominated. So the thing that seemed distinctive about her was that she had an extensive experience on the district court. Now Justice Sotomayor has some of that, but I think it was of all justices on the court, she was the one that had the lion's share of her public service, relevant experience was on the district court. So I was wondering, would that be particularly relevant? Now I haven't seen too much of that, but she has been very distinctive in a kind of surprising way, is that she is such an active, I think, leader at oral arguments. In the first session, I think she had by far the most words spoken at oral argument, and it wasn't the Justice Breyer kind of long monologues. It was a lot of questions, and I do think she has a very different style from any other justice on the court. She doesn't so much use the tool of the gotcha or the hard questions that Justice Kagan or Justice Alito do, or kind of she asks kind of surprising, thoughtful questions that have a lot of follow-ups and that are fairly lengthy. And it's just she's almost like the dominant voice at oral argument, at oral argument questions, which I think was interesting and kind of surprising, because she'd never, at least not for any meaningful time, been part of a multi-member bench. She was on the circuit for a little bit. To have someone that used to be a district judge that got to ask all her own questions to now be part of this non-justice court and to dive right in and ask, I think the volume of questions that she would ask as a single justice, I think as judge, I think has been really interesting. Has been a really good addition to the court, and I think it has helped oral arguments. I think, in a way, I personally prefer to the Justice Breyer style that she replaced.
Yeah. Oh no, I was going to say she has impressed in her first few arguments. I mean, she's not shy about just kind of jumping in and engaging, and so it has been impressive. She just kind of a quick anecdote. So earlier this year, last year, well, I guess this year, whenever she was nominated, but there was all the speculation about who's going to get the nomination, who's it going to be, and there were various candidates. And so I had a DC Circuit argument where she was on the panel, and so it was like a Zoom argument, right? So there's Tom, sitting in his office, in front of his computer, getting ready to go, right, all this. And, she was on the panel, so I was very excited about appearing before her. And so the argument starts at 9:30. So I get 9:25, okay, my cell phone starts exploding. And I'm like, Jesus, I told people not to, so I'm looking, and it's like, Biden just announces he's nominating her to the Supreme Court. And I'm like, no way! And then people are like, dude, that's the judge you're arguing. I'm like, I know that. I know this. So I'm like, well, there's no way she's going to appear because, the biggest event in her life, is she going to just do this, random D.C. Circuit ad law? So, bang, the Zoom starts, and lo and behold, there she is on the screen. So, what do you say? Congratulations, I just heard the news. No, the answer is you don't say that. But I was even more obsequious than normal. That is a great question, Judge. That's a great question. Anyway, so I was impressed with her during the argument. We won the case, so I like her already, and she's been really impressive so far.
Obviously it's just from one argument, but did you feel like listening to the argument and then fast forward to when you're listening to the Scottish arguments, you got the same tenor, same tone, and all that stuff?
She does, although actually surprisingly, she's been a lot more kind of engaged and aggressive kind of in the Supreme Court. I say aggressive in a good way, but on the Supreme Court than she was, kind of in my case. But again, my case is a little sleepy than that.
I was gonna say, but maybe more interesting than random for a case.
So,
at the U.S. Supreme Court. The second big feature, and this is something that's been a talking point, especially for those criticizing the court over the last couple of years, is the way that the quote-unquote shadow docket, or more like the emergency docket, has changed. And we saw this beginning last year, starting with the Texas SB 9, Texas abortion law, and then going to the two vaccine mandate cases, where the Supreme Court, in big emergency docket cases, has been setting the cases for really fast briefing, oral argument, and soon-to-be decision. And we saw those three cases decided last term in that way, although we still had some traditional emergency docket short orders. I had a case in the Clean Water Act context where they granted a stay. But they're doing this longer form argument now. And I think you see, as you have the Biden administration getting more of its initiatives blocked nationwide, you suddenly hear a lot less criticism of the quote-unquote shadow docket from the left commentariat and also from the justices. If you think about the vaccine mandate cases, you didn't hear too many folks who ended up either in the majority or the dissent from the left on the court criticizing the fact that the court had taken those issues prematurely. And I think you'll see a lot of the same dynamic in a case that isn't really slated for our discussion here, but certainly welcome your questions about the Biden student debt forgiveness plan, where the Supreme Court got some emergency stay applications from the USSG when the 8th Circuit had blocked the student loan forgiveness program nationwide. The Biden administration, speaking to the Solicitor General, put forward a traditional stay application, and what they did, and this is something that all stay applicants that are of any sophistication do now, is they write this 40-page stay application, and on the last page they say, for all those same reasons, this court could choose to grant this as a petition before judgment, and we're not going to say why any of those standards are satisfied, and the Supreme Court, and that's what happened in the vaccine mandate cases, and that's frankly what we did in our Clean Water Act case last year. But the Supreme Court didn't issue a stay, but it granted the Biden student loan decision for quickie merits, where it will be quickie merits briefing and oral argument and decision. And this seems to be a way that the emergency docket or the shadow docket is now being bifurcated. For the kind of important ones to not that important, or party-specific ones, they'll do it on the old shadow docket, emergency docket way, which is they'll issue a short order and then maybe a dissent. And then for these really big ones, like Texas abortion case, the vaccine mandates, and this one, you will get often a full briefing schedule with opportunity for amici and for a quick decision. And speaking of opportunity for amici, just today, the U.S. Supreme Court issued revised rules, and most of those revised rules are not going to be relevant to you guys for a while. But the one little one is they said that the amicus briefs at the stay stage are discouraged now. But now that they're doing this new thing with the emergency document, where they're sending for plenary argument, obviously there's going to get tons of amicus briefs in the student loan case and these other cases that are going to be taken from the emergency docket and plucked on the merits docket, but also on an expedited basis.
Yeah, no, it's well said, and I agree with that. I mean, the shadow docket is something that has existed, really since the origin of the court. I mean, the Supreme Court, frankly, all courts, can and do decide cases under exigent circumstances when necessary. I mean, the classic example of shadow docket cases would be execution cases, where, a state is going to execute someone, and the Supreme Court has to make a decision in very short order because there's kind of a time limit going on here. And so, the idea that there's something inherently illegitimate or perverse, or they're shrouding their processes in secrecy, I mean, it's kind of ridiculous. Again, courts have to do this. If there were situations where the court had the luxury of, full briefing and argument, but that's a process that can take, a year or more. Often it does take a lot more than that, and so certain cases just can't be resolved that way. So again, it is criticism that you hear a lot, but at least to my mind, the vast bulk of it is misplaced.
Yeah, on the speed thing, think about the vaccine mandate cases. If the court had waited until the lower courts had decided and granted cert now, notwithstanding the signs that are still in your law school of you should wear your mask, which I'm glad no one's doing, no one's going to be pushing those vaccine mandates anymore. It would have been moot or functionally moot. The Supreme Court, in order to weigh in on those things, they did reach a split decision. They said healthcare worker mandate okay, OSHA mandate not okay. They needed to weigh in then. Otherwise, you would have just had different circuits in the circuit lottery or forum shopping dictating these huge important issues that really need to be settled for the nation by the highest court.
Right. I like how you're working the amendments to the Supreme Court rules.
I was reading it this morning.
No, it is something that's actually of great tangible importance. Like, among other things now, in your table of authorities, you cannot have the word passive, a passive.
Why do they do that? That's only the BC Circuit does that. It's so annoying.
Well, it's funny because it's like one of those de minimis things, and why do Supreme Court lawyers even care about it? But I tell you, there's no greater professional humiliation in life than you file a brief that gets bounced by the Supreme Court because you didn't conform to the table of authorities, and you have to go to your partner or go to your client and say they bounced our brief because I didn't check the rules on table of authorities. So it's important stuff.
So that rule change is terrible. I don't know why they did it. I really love the other rule change they did today, which is that you don't have to ask for consent for certiorari amicus briefs. This is the most annoying exercise ever, and it's like a trap for the unweary, the 10-day rule.
It is. All right, so Misha, let's talk about some cases. You want to start us off on the docket?
Right, so I think one of the cases that's been getting the most notice is the one that's going to be argued tomorrow. It's a case out of North Carolina, something dubbed the Independent State Legislature Doctrine. And basically what the Elections Clause of the U.S. Constitution provides is for, and I'm going to paraphrase, you can kind of take out your pocket Constitution to get the exact phrase, is that for congressional elections, they're going to be administered as the legislatures of the states provide, unless Congress says otherwise. So the question in this case is, when a court in a redistricting case strikes down a state legislative redistricting map, congressional map, under a state constitution, and then draws a new map, is that constitutional or is that unconstitutional? And what happened in North Carolina was the North Carolina Supreme Court, interpreting the free and equal elections clause of the North Carolina Constitution, determined that hiding within that clause was a prohibition against partisan gerrymandering. And the state Supreme Court invalidated the congressional map that had been adopted by the state legislature of North Carolina, and as a remedy drew a new map. And so the case went up to the U.S. Supreme Court on the argument of whether the North Carolina Supreme Court had violated the Elections Clause because it was the legislature that has to regulate elections, which has been interpreted to include redistricting. Now there were, to my submission, two kind of fairly extreme or kind of bright line approaches primarily proposed by the parties in this case, the North Carolina legislature on one hand, and the North Carolina Attorney General and those supporting the state Supreme Court decision on the other hand. The argument raised by the North Carolina legislature and those who supported it was that the legislature, as used in the U.S. Constitution, means legislature, which means that all redistricting and other election related rules as they relate to congressional districts must be decided by the legislature. It doesn't matter what your state constitution says, but state judicial review or anything like that, it must be decided by the legislature. Now the folks on the other side took a kind of the opposite bright line, which is that legislature is in the Constitution, but the legislature's actions are necessarily limited by the state constitution. So the state constitution significantly limits what the legislature can do, including, as the state Supreme Court interprets it, to prohibit partisan gerrymandering, then that's okay, and that conforms with the U.S. Constitution's elections clause. Now, I, representing a group of voters who had challenged the New York congressional map as unconstitutional under the New York Constitution, filed an amicus brief trying to propose a middle ground position, and certain states also independently proposed the same middle ground position. And we took it as a kind of a hypothesis that the Supreme Court, at least a majority of it, wouldn't be pleased with either of these two extremes. On the one hand, if you take what the challengers, what the North Carolina legislature takes seriously, then you likely have to at least repudiate the dicta, the very considered dicta in Ruccio, which said that while the federal courts were going to be out of the business of partisan gerrymandering, states could enact state constitutional provisions that control partisan gerrymandering. The U.S. Supreme Court said that. Now that was dicta, but it was kind of the promise to the states that they could do this now that the federal government's out. And I think the majority, the conservative justices, most of whom were on that opinion, might be a little loath to take that back so soon thereafter. On the other hand, there are, I think, enough justices that have expressed significant discomfort with the notion that the legislature, as the phrase legislature as used in the elections clause, means absolutely nothing, and said, well, we need some limiting principle here. So what we proposed in our amicus briefs, and what the states who also independently came to the same conclusion proposed, is something called a clear statement rule, which is that if you're going to have state courts or state executives getting involved in congressional elections, there has to be a clear statement in the state law, either in the state statutes or in the state constitution, which under the Arizona Independent Redistricting Commission case is the equivalent, if adopted through a referendum process, is the equivalent of a legislature that specifically spells out what the roles of those bodies are. And theoretically, the North Carolina Supreme Court's decision could be overturned under that theory, and yet all of the actual textual reforms that lots of states, including New York, have adopted to control partisan gerrymandering will remain in place. Now we'll see if the Supreme Court picks one of the two extremes, a compromise position, or something else. But this is a case where I have a really hard time predicting how it's going to come out, because there are arrows pointing in two directions. The two approaches presented by the parties certainly don't seem to have any element of compromise on them, and only from a couple of amici do you have any sort of compromises put before the court.
Yeah, it's a fascinating case, and to your point, Misha, I mean, I guess in terms of the arrows pointing in different directions, I guess one of the aspects I find particularly interesting is that it's a case in which, on one hand, you obviously are going to make initial resort to, the text of the Constitution, obviously, and, practice at the time of the founding. And if you read the briefs, I mean, it really is kind of a great little, textbook on kind of whether this and when this issue was debated, not just in the federal convention, but also in the state conventions, what the practice was at the time. I mean, there, paragraph after paragraph that would begin like, as Justice Story said, kind of these wonderful things, and it's just a fascinating historic read to get that sense. So you've got text and history on one hand. On the other hand, you have a consideration that I think has been driving a lot of the Supreme Court's jurisprudence in this election law area in recent years, which is the practical implications and the feasibility of implementing whatever rule of law they devise. I mean, in the partisan gerrymandering case, for instance, it was clear the Supreme Court just didn't want federal courts to be in the business of kind of having to, get their hands dirty in drawing maps and things like that. And they basically said, as you said, the states can, police all of that. We're just out of this business. And so I think you are going to see a lot of questions going not just to historic practice and those things, but also about how are we going to articulate a rule of law that on one hand will, ensure that, rogue state legislatures don't go crazy and do bad things, but also ensuring that the federal courts don't get inundated, especially around election time, with having to police all of these disputes. Because I think there's one lesson that the court has learned very painfully over the years, is that when the court gets dragged in, especially in a post hoc posture after an election has occurred and is asked to adjudicate these rules, where there's obviously going to be a clear outcome in terms of anointing one candidate or the other the winner based on what they decide, that's just not a place the court really wants to occupy, at least unless when it absolutely has to. So, okay, I guess next case, why don't we talk about the case a lot of folks are focused on is the affirmative action case. This is the Students for Fair Admission against Harvard and the University of North Carolina. This case, I mean, you guys, I'm presuming, a base level of familiarity with this case. It's no surprise that this case is on the court's docket. I said at the outset that when the conservative majority kind of, came in and 6-3, that there were a lot of issues that everyone suspected rightly that the court would be taking a look at, adding to the docket, and revisiting. This was at the top of the list. You all probably remember there was the Grutter case. That was the affirmative action case coming out of Michigan, where Justice O'Connor famously said that affirmative action has a time limit. She's put 25 years on the decision, and so she wrote that. And so I can tell you that there were a lot of conservative appellate lawyers around the country kind of looking at their calendars, looking at the watches. And it actually is a few years early. It's not quite 25 years, but it's within that margin. Close enough.
But Kavanaugh said that if you look at the admitting class when they're going to graduate,
see,
they actually get to the 25
that's why he's on the Supreme Court. Brilliant. Smart guy, Kavanaugh. So everyone knew that this was going to be coming back. So the challengers brought the case. As you probably know, they named two defendants because they wanted a private university, Harvard. They wanted a public university, University of North Carolina, because technically the two colleges, the two schools are governed by different regimes. The public university is subject to constraints of the Constitution. Private university, you got them under federal statute, Title VI. The legal tests historically have been the same, so there's not a huge amount of difference in terms of kind of how you would apply the law to the affirmative action programs of each school. The argument went, again, I think probably as most people expected. There didn't seem to be a lot of love for these affirmative action programs among the 6-justice conservative majority. There were various points in the argument where kind of some of the liberal justices were kind of, offering as kind of, they often do, and then judges, I think, when they sense the tide of the court may be going a different way, they start coming up with off-ramps and ideas to limit the scope of the holding, or procedural issues, or rightness, or state, things like that, to kind of avoid a destination of a merits decision. And so that was floated at various times during the argument. I don't think anything got a lot of traction. I think the only question really kind of going into it was whether the Supreme Court was simply going to say, no more. This is it. We're not going to allow race to be considered kind of even in a narrowly confined way. We're just going to have schools get out of the business of considering it at all and just make a clear rule that can be applied. Because I think one of the frustrations that I suspect the Supreme Court, but certainly the lower courts, I think, have encountered over the years in trying to police the limits, first of Bakke, then of Grutter, is that you never know kind of what's going on behind closed doors. You never know exactly how race is being considered, how much it's being weighted, whether or not they're complying with the Constitution. It can be very, very difficult to police the bright lines in this area. And so I suspect that what may be driving the conservative majority is saying, like, kind of, this has gone on long enough, it hasn't worked, it hasn't made the changes we want. We said 25 years, we're almost at that point, we just need a clear line here. So again, based on the comments and argument, the questions, again, always hazardous trying to predict the outcome, it looks like this may be the case where the Supreme Court finally takes that step and holds this in the consideration of race in the admissions process just to be unconstitutional.
Yeah, this one I'm more comfortable making a tentative prediction. I think that's, I'm not seeing, the fifth or even the fourth vote to keep affirmative action as legal. And the question is, what is going to be allowed as schools try to work their way around that? There was a lot of discussion about 10% plans. There was discussion about, well, could you put, could you kind of indicate your race in your college essay? And then say, well, and then the schools will consider that holistically, and lo and behold, we'll end up with the same racial balancing or whatever. But I think that at the end of the day, this is going to, the 25 years will be pre-terminated at 22 years, and the schools will have to deal with a different legal regime, which I know a lot of them will be unhappy about, but I think them's the breaks.
Yeah. It's hard for them to kind of see them giving an extension, saying, okay, we'll let it go another 10 years, and I mean,
yes,
I think,
3 more years, sunset.
I think you're right. So, okay.
So speaking of considering race, the next case I'm going to talk about is Merrill, which is how race can or should or must be considered in redistricting. And, Merrill is a Section 2 of the Voting Rights Act case, but in order to understand why that case arises as it does, it's actually important to talk about another line of cases, which arose at around the same time as, the affirmative action line of cases, which is the Shaw line of cases, which under the Equal Protection Clause puts a high disfavor on redistricting based on race. And in fact, Shaw, it was the justices that were writing and most supportive of Shaw were the same justices that were kind of in dissent or in the pluralities in the affirmative action cases. As they were saying that, well, you're putting people in congressional districts based on race, and sometimes it was being done to try to help minority groups to have more representation, and they were using the same kind of reasoning as in the dissents in the affirmative action cases or in the Becky kind of concurrences, to say that this needs to be disfavored, or race can only be done in redistricting, as traditionally race can be done, which is only if you can satisfy strict scrutiny. Now, strict scrutiny in almost all fields is fatal in fact, but with regard to redistricting, the Supreme Court has, at least in very strong dicta, recognized one important exception to when not only can you draw districts based on race, but you must, which is that if Section 2 of the Voting Rights Act, as interpreted by the U.S. Supreme Court, it requires a majority-minority district, then not only is it not unconstitutional to draw your district based on races, you have to create majority-minority districts if Section 2 of the VRA requires it. And what happens is this puts states in a really tough position, because if you try to draw maps race blind, as you would, as Shaw seems to indicate, but in fact the Supreme Court's case law under Section 2 of the VRA requires you to create a minority district, your districts get struck down. On the other hand, if you try to create majority-minority districts because you think that's a good thing, or you think Section 2 of the VRA might require it, but you're wrong, then your map could get struck down under Shaw. So you're kind of in this vice. And because these two doctrines live so close and almost symbiotically, maybe that's not the right term, yin yang or whatever it is, the greater Shaw is, the narrower Section 2 of the VRA is, and vice versa. So the case in this Merrill case lives at the intersection of those things. And in order to understand Merrill, I'm going to quickly give you a very, very quick primer on Section 2 of the VRA. In order to have to draw a majority-minority district, the following criteria need to be satisfied. First, there has to be enough of one minority group, not multiple minority groups, one minority group within a geographically sufficiently compact area to make up a majority of that district. Two, the minority group in that area must vote cohesively together. And three, the white majority must generally vote as a bloc to defeat the minority group's candidate of choice. But then there's another consideration. Even if all three of those are satisfied, then there's a kind of an all things considered balancing about whether you should draw a majority-minority district. So what happened in Merrill coming out of Alabama is that I think a fair application of the first three preconditions of a Section 2 VRA, at least as traditionally conceived, would require you to create a majority-minority district, a bracket that all things consideration. On the other hand, you would have to draw somewhat unusual districts to do it. In fact, there was in that case simulations done. What would happen if you draw districts without considerations of race? And even the expert that the challengers hired, he couldn't draw out of all his tens of hundreds of thousands of simulations, not a single simulation, not taking race into account, drew two majority-minority districts in Alabama. So here you have a collision between the race neutrality requirement of the Equal Protection Clause and the traditional articulation of the first three of the three preconditions for drawing Section 2 of the VRA. So what the challengers in Alabama did is they attempted to get the Supreme Court to change the first precondition of Section 2 VRA saying, it's not just that a majority, enough minorities, folks from the same group to create a majority-minority district. It basically has to be creating that majority-minority district by, race blindness, which is a little bit odd. And the U.S. Supreme Court, at oral argument, very strongly pushed back against that. But the U.S. Supreme Court is about increasing race blindness, as Tom just talked about in the affirmative action cases. So when a lot of the questions that the Supreme Court asked pointed towards making the race neutrality consideration much more robust in that all things considered inquiry. And if the Supreme Court does it that way, and it seems to be that it will tend to shrink the cases where race conscious jurisdiction is mandatory under Section 2, and increase where it's unconstitutional under Shaw. But it will not, contrary to the efforts of folks on both sides, lead to a lot of clarity. Because if the Supreme Court just says, as part of the all things considered inquiry, at the back end of Section 2 of the VRA analysis, you just have to give more weight to what a race-neutral plan would look like. What's more weight is often in the eye of the beholder, and you're going to have a lot of variance based on what judge you happen to get as to whether your map's going to survive on either end. So if you're a legislature, you're not going to know if you're going to get your map struck down because it's too race conscious under Shaw or not race conscious enough under Section 2 of the VRA. So it won't, I think, solve the fundamental problem that the Supreme Court has created in the way that they've articulated these two doctrines.
It's quite a thicket. Okay, so the case I want to touch on next is the case that is closest to my heart in the docket this term, and some people kind of focus on whatever, abortion or gun control or affirmative action, but the real story is personal jurisdiction, right? So personal jurisdiction is, and I don't mean to bring back horrifying memories of Civ Pro, but this case, Mallory versus Norfolk Southern Railway, okay, this involves the pernicious doctrine of general jurisdiction. Okay. Now, general jurisdiction we all learn about in Civ Pro, but I have to say I don't think there is any greater gap between what you learn about a doctrine in law school and then how you actually experience it in the real world. And this is why. General jurisdiction, as you know, provides that you can sue a defendant, a corporate defendant, in any jurisdiction where that defendant is basically doing business on any theory. So it doesn't have to be connected with the case. If you've got a slip and fall case, the plaintiff is in a Walmart in Montana and slips and falls. If you've got general jurisdiction over Walmart in, say, Massachusetts, you can go to Massachusetts and file that lawsuit there, and the courts will adjudicate it. Again, in theory, sounds sensible. These big companies, why can't you sue them everywhere? They can, they're doing business, blah, 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 blah. But in practice, it leads to all sorts of pernicious conduct and skullduggery by the plaintiff's bar because it is obviously conducive to forum shopping, to say the least. And this case, this Norfolk Southern case, is a perfect example of that. This case arises from basically a slip and fall injury by a railroad worker. And if you look at where these cases are filed, it is a rare day when there's actually filed in the jurisdiction where the worker slipped and fell. Typically what they will do is they will scout out all the possible jurisdictions across the landscape where they could file and file in the most plaintiff-friendly forum. So surprisingly, Montana gets like 90% of these cases. I mean, I'm making up the number, but a high percentage of these cases, a disproportionate percentage. So too Pennsylvania, where the this case, Mallory versus Norfolk Southern, arises. And so the question in this case is whether a state can require a corporation to subject itself to general jurisdiction as a condition for doing business. So basically what the state of Pennsylvania would say is, look, if you, corporation, want to come to Pennsylvania, you have to get a business license, and as a condition of that, you are opening yourself up to be sued for any claim arising under any theory anywhere in the United States. Welcome to the Keystone State, right? It's not like the warmest welcome, but that's what they will do. And so the question is that registration by consent constitutional? A few years ago, the Supreme Court decided this case, Daimler versus Baumann, and there the court basically rewrote the rules of general jurisdiction. Before Daimler was decided, you could sue a big corporation in any state, anywhere in the country, as long as it was doing business there. So if you're Amazon, Walmart, you name it, you could be sued in all 50 states under any theory the day before Daimler was decided. After Daimler was decided, the Supreme Court limited it just to 2 states, your state of incorporation and where your headquarters is. So for all these companies, you go on day 1 before Daimler, you can be sued in 50 states. The day after Daimler, you can be sued in 2 states. The danger of the Mallory case is that it threatens...
Under general jurisdiction.
Under general jurisdiction, right.
If you're specific, you can still get it.
Yes, specific you can always get it, right?
Yeah.
But this is under any theory. And so the danger of the Mallory case is that if the Supreme Court endorses this registration by consent theory, that you're basically overruling the rule of Daimler, because all states can, or at least potentially could, require you to consent to general jurisdiction as a condition of doing business. There are many problems with this. I guess one is just this idea of registration by consent is somewhat of a legal fiction, at least as it arises in this case. Consider Norfolk Southern, right? In other words, it runs a railroad. And you can't really say to Norfolk Southern, oh yeah, if you don't want to do business in Pennsylvania, yeah, no problem. Just pick up those tracks and kind of move them across the state line to Maryland, right? No, you can't do that, right? So it may be a realistic option for some companies, but it's obviously not a realistic option for other companies. We'll see where the argument goes. I mean, knock on wood, or we'll see where the case goes. The argument, knock on wood, seemed to be leaning against overruling Daimler and rejecting this general jurisdiction by consent theory. Not entirely sure about it, and again, this is one of those cases where the conservative justices were not speaking as an ideological bloc. But I'm reasonably optimistic that, at the end of the day, reason will prevail, and that the court will adhere to what at least most of us think is, most reasonable people think, is the original understanding and conception of general jurisdiction, that it's limited to a narrow band of states, whereas specific jurisdiction, which is case-related jurisdiction, will always exist and really should be the primary basis for any exercise of personal jurisdiction in the courts of the United States.
Well, one thing I thought was interesting about that case, you mentioned other states doing it, and Pennsylvania didn't defend its own law at the U.S. Supreme Court. All the states, sans Pennsylvania, actually came in against the Pennsylvania law, which might be a little bit not intuitive, because like, why wouldn't states want to do this? Why wouldn't they want to grab up all these companies, drag them to their own courts? But if you can do it to every other state, 49 other states can do it to you. And I think states were more comfortable adjudicating the cases that were more grounded in what was happening in their own state, rather than what happened in the Norfolk case, which is, I think the accident took place in Florida or something.
Yeah.
Anyway, somewhere there was no connection at all to Pennsylvania. And to the extent that state courts have limited bandwidth, you would think that most states would want them generally sticking to the business of what's going on with Pennsylvanians, and not like becoming a forum for forum shopping plaintiffs.
Right. But and there's, I think, kind of a to your point, there's a state sovereignty issue here, because if Pennsylvania is adjudicating disputes that really have no material connection to the state of Pennsylvania, that means by definition, Florida is not adjudicating a case over which it really should be exercising jurisdiction. So there's kind of an affront, I think, to state sovereignty. If you could have all sorts of events and accidents and facts that give rise to litigation occurring in state A, but then those disputes are all resolved in state B because the plaintiff's bar thinks that state B is a more favorable forum, something's kind of wrong with that picture.
Now look, there's nothing wrong with forum shopping. I forum shop all the time, and it's an obligation. Look, there's a reason
it's not forum shopping when you do it, right?
There's a reason that all the challenges to the Biden administration are brought in the Fifth Circuit, and all the challenges to the Trump administration are brought in the Ninth. Forum shopping is American as apple pie, but courts need to think about the rules that they create that encourage or discourage forum shopping, and certainly those concerns were at play in the Norfolk Southern oral argument. The last case I'm going to talk about is one that was actually argued yesterday, and I managed to get through most of the oral argument. If you guys don't know, the U.S. Supreme Court oral arguments, after they go up about a day later, you can get them on your OEA app on your iPhones or your Android. But if they're not up there yet, you can just listen to them right directly from the Supreme Court's website. And the case that was argued yesterday was 303 Creative. This was in the species of the Masterpiece Cake Shop case that was argued and decided a couple terms ago, which is basically what can states do to force folks to abide by non-discrimination laws vis-a-vis the First Amendment, when those laws would force service providers to provide their creativity and their speech to causes they don't agree with. And the way that this arises most commonly these days is service providers that do not want to provide services for same-sex weddings. So back in the Masterpiece Cake Shop case, there was a cake designer that didn't want to design cakes for same-sex weddings
Or for he wouldn't do Halloween cakes either.
Is
Wouldn't
that-
do Halloween, and he wouldn't even do, get this, divorce cakes. Like, I didn't even know that was a thing. Like, people were like, I'll have my usual order. I mean, like, people.
I did take a friend we did do an unbachelor party with a friend once who had a messy divorce. We took him to Vegas, so maybe that's in the same species of thing. But yeah, so and then in the Masterpiece Cake Shop case a couple of years ago, the Supreme Court kind of punted on it based upon some statements that some of the commissioners had made that were very antagonistic towards religion. So they just decided that case based on those statements. They didn't decide this issue. In this case that was argued yesterday, this is this company 303 Creative makes websites. They make and they'll make among their suite of services they make wedding websites. But the owner of it and the primary artist, she doesn't want to make the subset of websites that she makes for weddings. She will not make them for same-sex weddings. And so the issue was joined. But then a lot of the disagreement in the oral argument and in the briefs was fairly narrow. Pretty much everyone acknowledges that you couldn't like require a poet to like compose poetry in support of an event that they don't agree with. And on the other hand, there was agreement on the other side that if it was like someone that like delivers the flowers in the truck, that's not artistic or First Amendment at all. So that you couldn't be a truck driver and say I won't haul flowers or stages to same-sex weddings. So the issue ends up being narrowed, and I find it somewhat unsatisfying where the lines are drawn. And I think it's the most telling was this amicus brief that was written by Professor Eugene Volokh in the Masterpiece Cake Shop case and then the 303 Creative case. In the Masterpiece Cake Shop case, he said he was actually against the cake maker, saying that wasn't expressive. But then on the website designer, he was with the website designer and said that was expressive. Now maybe my intuitions are the opposite, or maybe different than his. I thought that someone that designs a cake that makes it really kind of creative and that's really art. Whereas if you're just like drafting a website and saying, the ceremony is here or whatever, maybe that feels equally creative, or maybe even a little less creative than the cake design. But I could certainly see the intuition on the other side. But if the doctrine is going to cash out to the kind of distinctions that Professor Volokh was trying to articulate in his amicus briefs, and really, and I'm not trying to criticize him. If you look at, given that the concessions on both sides of this case, the truck driver on one hand versus the poet on the other hand, you really do end up with the fight being about what are your intuitions about what's more creative or not, what's more artistic than not, what's more First Amendment-y than not, and it feels a little unsatisfying. But I don't really have a better answer because there's a lot of smart people that work in this area, and if both sides, both the people who are more against the anti-discrimination laws and more in favor of the First Amendment are coming up to narrowing the band to that disagreement, maybe that is where it should land. I just find it a little unsatisfying because I don't know that the intuitions of people, even the majority of people, are going to be consistent across the vast majority of the real edge cases.
One other interesting aspect is this web designer. I found out apparently she lives like 4 blocks from the cake shop, the Masterpiece Cake Shop in Colorado. Like, what are the odds, right? I mean, like, it's like this 3-block radius in Colorado is like a hotbed of constitutional debate. I don't know. Anyway, so my last case, it really arises from and those of you who have visited exotic locales, California, will appreciate this, right? You're in California and you're going to enjoy a nice cup of coffee or something, and you look at the cup and it says something like, "Warning, the beverage you are about to consume is known to the state of California to contain substances that will cause cancer. Something, I mean, like, you know, lovely things like this. Or you're about to go in a building and it says, warning, the building you're about to enter contains toxic materials that will kill you within 5, you know, like whatever. So California is really into these sorts of warnings. And one of the things they have done, it's not really a warning so much as kind of, you know, that they have their own view of how things should be done, gave rise to this case on the docket involving the pork producers. This is a Commerce Clause case, a dormant Commerce Clause case, and it basically involves a challenge to a California law that prohibits the sale within California of pork products in cases where the pigs were not housed in humane conditions, again, based on what California would define. And so the question here is does this violate the Dormant Commerce Clause, in that the commerce that California is effectively regulating does not occur within California, it occurs within, say, Iowa. And so the question is California essentially projecting its laws extraterritorially in a way that would regulate commerce occurring beyond its borders. California's defense is to say, well, there's no extraterritorial effect. There is. I mean, Quinn said we don't control it. All we're saying is we always have, you know, states have the police power to determine products that are sold within its borders. That's all we're saying. We're just not letting this be sold here. Whatever Iowa wants to do, you know, they can do it. We're just saying we're not going to allow those products to be sold here. So the argument was interesting, and, you know, here too, again, conservatives are can go different ways on it. I mean, there's some conservatives who don't even think there is a dormant Commerce Clause. I mean, it doesn't actually appear in the text of the Constitution, so I get that argument. But there are other conservatives who say, well, it's, you know, that ship sailed a long time ago and it exists. But the other issue that all the justices were wrestling with is, if the court were to bless California's scheme, where does it stop? In other words, could Texas pass a law that says we will not allow products to be sold within the state of Texas that were manufactured by illegal immigrants? Or, you know, that you could see states wanting to encourage vaccinations. We won't allow products to be sold if it were manufactured by workers who are not subject to a vaccine mandate. In other words, you could instantly categorize various states with their various policy preferences and basically saying, thou shalt not sell within our state any product that results from, you know, insert, you know, disfavored practice here, right? Where does it end? Certainly there would be some states in such a regime that would have greater control. In other words, if California says we're not going to allow products to be sold in California, that's a big deal for most manufacturers, given the size of the state. Whereas if, you know, Delaware or Wyoming or, you know, smaller state did it, people might be like, well, that's quaint, but, you know, it doesn't matter. So justices were very, very concerned that if they approve this, what is to stop other states, you know, particularly states that have shown some degree of creativity, and the fact, you know, Florida, you know, Texas, you know, the mind could scheme and dream up all sorts of creative laws intended to influence conduct throughout the United States. So I think justices of all political stripes were thinking, oh God, you know, are we going to unleash this you know, internecine war where states are trying to regulate one another? So it does seem a little unlikely that they would give California the green light. And actually, Justice Jackson came up with what possibly could be an attractive solution, where she said, why doesn't California just do what they love to do, which is label? Just put a label saying, FYI, citizens of California, this product was manufactured in a way that we don't like. You know, it's still on the grocery shelf, so they're not stopping commerce. And California citizens want to buy it, great. If they don't want to buy it, great. But they're not actually stopping the product from crossing state lines. So we'll see if that compromise holds any traction for the court, but it's an interesting case. It's one of those classic cases where you got to think about, all right, we decide this case, what's the next case coming down the line, and then the case after that.
I mean, I gotta say, from my reading of what the founders were concerned about, that case coming out the wrong way would be the most nightmare scenario. I mean, that was one of the key reasons they abandoned the Articles of Confederation for the U.S. Constitution, was that the states were being balkanized in their economies, and it would be very easy for states to balkanize the economy if that case becomes the wrong way. You could point in the opposite direction. In Texas, they could say, we're not going to have any goods sold here that's produced by any business that funds the helps pay for the abortions of their workers. California did the exact opposite law. We're not going to have any goods sold here unless the company pays for the abortions of their workers. And any national company, we just have to decide if it's going to do business in California, Texas. There's no way around it. Or they'd have to balkanize their workforce. It'd be just a total nightmare.
All right, I'm inferring that we may be at the Q&A portion if we have time for that.
Yes, we have time for a couple of questions. Matt?
Thank you both so much for speaking. This was really interesting. One of the things I find interesting about Morby Harbor and students for fair admissions is they involve controversial constitutional provisions, but also less discussed statutory provisions that could have implications for Morley Harbor's 2 USC 2AC and for the students with fair admissions, it's Title VII. So I guess I'm just curious if you think it's possible that the court might rely on one of those statutory provisions in either case instead of doing the big constitutional question that has broader implications, especially if there might not be enough votes for a continuance in the court without it.
No, we certainly haven't had the argument, and more than the statute didn't get much notice in the brief. I mean, it was mentioned in the briefs, but I don't think it was the focus. With regard to the affirmative action cases, I mean, Justice Gorsuch was interested in the statutory question, which would have some beneficial effect in that if North Carolina and Harvard lost on those bases, then Congress theoretically could repeal that statute or change it or allow something. But my hunch is that that's not how it's going to go.
I tend to think that's right, but I will say it's a great question because I think the tendency of many constitutional lawyers is immediately to go to kind of the sexy constitutional provisions at the expense of the statute. And to your point, I mean, and the way actually judges should operate is if you can resolve the case, short of getting to the constitutional grounds, that's how you have to do it because, I mean, the Constitution is forever, or at least kind of stare decisis, it will be forever, whereas the statute can be changed if Congress doesn't like the policy outcome. I tend to agree with Misha's point that if I had to predict, I would say probably not, although Justice Gorsuch's question did give me some pause when he kind of came out of the box like that. But at the end of the day, I tend to think, at least in the affirmative action cases, that they will ultimately go to the Constitution. That's my hunch. Good question.
I will do one wrinkle on more. While I don't think the federal statute is likely going to be it, although who knows what will happen tomorrow, is that one of the reasons that we filed in support of neither party in my amicus brief is there is a North Carolina statute that could be arguably read to assign the responsibility to the state Supreme Court, and if that statute means what North Carolina says, then that could end up making that case a big nothing burger.
Time for one more question. Georgia.
Miss Tseytlin, is that right?
Misha.
Okay. Well, from Alabama, we just say last name. First name is hard. But my question is, under your kind of moderate approach, with the scheme that Arizona came up with in the Arizona case, is that fair game? I mean, is it?
That's in the Arizona Constitution. The people adopted a referendum, and one of the points we made in our amicus brief was the Supreme Court would not strike down any of those reforms. All those reforms that the states adopted, Arizona, New York, etc. Those are in the text of the Constitution, and under the Arizona Independent Commission case, when you do it by referendum, that's the people speaking as the legislature, whatever you think of that, that's precedent. And so all those reforms would be in place. And what would basically not be allowed is what, for example, Pennsylvania did in the last decennium. Because the state Supreme Court basically decided we don't like the congressional maps, and they just made it up and adopted a new congressional map for Pennsylvania. That's the compromise we put forward to the court, which would, I don't know that it's not grounded in the original meaning or nothing, but like it is a compromised position between two positions that I think are going to be unattractive to the majority of the court. And sometimes second best principles is what the Supreme Court adopts. I think the anti-commandeering doctrine might be an example of that, where the Supreme Court, wasn't going to roll back, the New Deal, but wanted some protection where the federal government wouldn't completely roll over the states. So that was the thinking of it.
Thank you to Mr. Tseytlin and Mr. Dupree for joining us today for the Supreme Court Roundup. Thank you all for such a great quarter, and I wish you all the best of luck on exam.